I can. Can you hear me? Okay.
Probably Adam. Is the jail there? Victim's witness. That's probably Adam because his laptop.
That's a victim witness.
His laptop's broke or something. He's been using that one.
Osborne, case number 21 CR 138. Case before the court, Mr. Osborne was indicted on an F3 for aggravated trafficking in methamphetamines, F3 aggravated possession of methamphetamines, an F3 aggravated trafficking in methamphetamines, and an F5 aggravated possession of methamphetamines. This court did hold an arraignment on September 15, 2021. Mr. Osborne was given a $20,000 bond, and was set for bond review today at 10 o'clock. Mr. Osborne was given court-appointed counsel Denny Kirk. Mr. Kirk is present at this video bond review, as well as Mr. Osborne and Mr. King on behalf of the prosecutor's office. Mr. King, anything you wish to state at this bond review today in regards to this bond?
Thank you. Given the nature of these charges, that they involve narcotics trafficking, it's the state's position that the $20,000 bond is appropriate. Thank you.
Mr. Kirk, anything on behalf of your client in regards to bond?
Thank you. Would ask the court to consider a reduction in bond. My client, looking at, obviously we're at a disadvantage at this early stage. I don't have much information about him, but I did see his financial disclosure form. Looks like he is unemployed, lives with his girlfriend, and we just ask the court to consider a bond reduction.
Mr. King, anything further on behalf of the state?
No, Your Honor.
Upon review at this time, I think the $20,000 bond is justified. The court would remain bond of $20,000. Subject to any motions for bond review, Mr. Kirk, you might want to file in front of Judge Cost, but at this time, I do find that the $20,000 bond is appropriate. Anything further?
No, Your Honor.
No, Your Honor.
Nothing further to return. Mr. King, if you want to move on, have what happens here, maybe we can try the next one.
Okay.
I think that's the arraignment that they just put in there, Cindy.
Is it?
Yeah, that Geneva.
Okay. I guess we're going to arraignment next. Let's sit in if you want, Mr. King, it doesn't matter. The arraignment is dangerous, is that correct?
Yes, ma'am.
On the record, the matter of State of Ohio versus Geneva Dingus, case number 21-76, case before the court is an indictment, an arraignment on an indictment for aggravated possession of methamphetamine, violation of section 2925.11 of the Ohio Revised Code, which is an F5. Mr. Dingus, is that you present before the court?
Yes, ma'am.
Oh, it's Mrs. Dingus, I'm sorry. And ma'am, you have the right to have an attorney represent you at all stages of this proceeding, except you have applied for court-appointed counsel. So we'll review that application for counsel here in just a second. You also have the right to be served with this arraignment, at least, or with this indictment, at least 24 hours prior to today's arraignment. When did you receive a copy of this indictment?
I just got it this last night.
Gets to a lot of what happens. So Ms. Dingus, you do have the right to wait at least 24 hours prior to this arraignment hearing. This arraignment hearing, what we're going to do is set bond in your case. So do you want to wait 24 hours, or do you want to go forward today and just go ahead and set bond?
Let's go ahead and do that.
So you waive your right to wait 24 hours. You also have the right to have me read this indictment to you. Would you like for me to read your indictment to you today?
Yes.
So your indictment alleges that you violated the Ohio Revised Code section 29.25.11 for aggravated possession of methamphetamine. It alleges that the grand jurors of this county, in the name and by authority of the state of Ohio, upon their oath, do find and present that count one, on or about October the 23rd, 2020, and in Highland County, Ohio, Geneva Dingus did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation of section 2925.11 of the Ohio Revised Code against the peace and dignity of the state of Ohio. And your application states that you live at 702, is it? I don't know what the name of the street is. Popular Street?
Mm-hmm.
Is there an L in that?
Yeah.
P-L-A-R?
Yes.
Okay. And that's in West Union?
Yes, ma'am.
And who do you live there with?
I'm staying with a friend of mine right now because my mother had passed away Monday.
Okay. And you're not currently employed, is that correct?
Correct.
And how long has it been since you've been employed?
It's been since my mother passed. I was taking care of her.
Mr. King, just so you're not caught off guard here, I do not see a bond recommendation from the state. I'm going to be asking about that here in a couple of minutes, just so you can.
Okay.
And do you live with anybody in that residence, Ms. Davis?
Yes.
And who lives there with you?
Marlene Martin.
And who is that?
It's a friend of mine.
this address that you live at, are you buying or renting then, or is it somebody else's residence?
It's somebody else's.
And how long have you been there?
I just been there over a week.
Where did you live prior to that?
At 6280 Trot County Road, Seaman, Ohio.
And who did you live there with?
With Melissa Dalton as my mother.
And, ma'am, anything you wish to state in regards to your bond?
I didn't even know I had an indictment. I mean, it's all shocked to me since yesterday. I didn't even know I had an indictment out.
Mr. King, anything on behalf of the state in regards to bond in this matter?
Yes, thank you. I realize, Your Honor, that this is just a fifth-degree felony here. However, the summons was initially issued back in May. There was a failure of service on the summons. A warrant had to be issued in June, and there's been a warrant out for this defendant since June. If I understood her correctly, she's only lived at her current address for about a week. Seems rather transient. So based on all that, the state would ask that a $2,500 bond be set. Thank you.
So, Ms. Davis, Mr. King is correct. You are kind of transient. You haven't been at this residence very long, and that is the one thing that we're trying to do is reassure that you're going to reappear at these hearings. If you had longer time on your residence, I think I probably would consider an OR bond. But we've not been able to find you. There was no service in May. We've not been able to find you. I don't see any history of failure to appear. However, I'm going to agree with Mr. King at this time, $2,500 bond, which is a pretty low bond. This will be subject to a bond review within 48 hours set in front of Judge Cost. Judge Cost can take another look at it. He may give you an OR bond at that time, I'm not sure. But I'm going to issue a $2,500 bond plus an OR bond. The OR bond is a failure to appear. We promise to reappear at all future court appearances. If you fail to appear, it could be considered a fifth-degree felony, which puts you up to 12 months of detention. So your initial charge, you could serve between 6 and 12 months of bond. I think Mr. King was $2,500, if I'm correct.
That's correct.
And so this OR bond would be additional time on top of that if you fail to appear. So I am going to order that you reappear before this court for a bond review hearing. So Reno, did we get a date for that?
I believe it'd be Monday.
I think she's got another one for Monday at 47. You run and ask for the we'll get that bond review date and time here in just a second. But I am going to set you for your first pretrial on October the 6th at 1 p.m. I'm going to set you for a final pretrial on October the 20th at 1 p.m. And both of those pretrials and the bond review hearing will be by Zoom. So we'll get some information from you on that. I'm also going to currently set you for a jury trial on November the 15th at 8 a.m. Now again, your failure to appear at any of these would be considered a fifth-degree felony, so you need to make sure that you are present for these hearings. Do you understand that?
Yes, ma'am.
And did the jail get some information from you that has an email address that we can give you the Zoom link?
No.
So I think that they would get that from you. They normally get that. I think if you're able to make bond, you especially need to make sure that you have an email address on file for you. If you are able to make bond, I would order that you, again, have to pay $2,500 bond plus $171 service fee that would be paid to the public courts within 30 days. You would have to report weekly to the probation department, undergo any random drug testing that might be ordered. Keep them informed of your current telephone number or any work phone numbers. I would order that you remain on house arrest at 702 Paco Street in West Union and not leave the state of Ohio. I am appointing an attorney for you, and that would be Danielle Witt. Danielle's name and phone number will be in the info contained in a copy of the entry that you will receive. And did you get that bond review done? 1 o'clock?
Yes, ma'am.
So bond review will be Monday. So September 20th at 1 o'clock, right? At 1 p.m. Do you have any questions about any of that? Mr. King, anything further?
No, Your Honor.
Nothing further, Mr. Court notes the record that Ms. Henry is present by video through Highland County Jail. Mr. King is present, and also Ms. Capper both by Zoom. This matter is set for bond review. Ms. Henry was originally indicted on September 14, 2021 on 1 count of burglary, violation of section 2911.12, which is an F2. She was indicted on theft, violation of section 2913.02 and F5. Court finds that Catherine Hacker was appointed as court-appointed counsel. Ms. Henry was, Ms. Henry was given a $5,000 bond. And this matter is before the court for bond review. Mr. King is present on behalf of the state. Mr. King, anything that you wish to state in regards to bond review today?
Yes, thank you. Given that the defendant is charged with a second-degree felony, it's the state's position that bond is appropriately set at this time. Thank you.
Ms. Hacker, anything that you wish to state in regards to bond?
Your Honor, I believe that Ms. Henry is not a flight risk. She does have a home that she can return to, or she granted bond in. From my reading of the initial report, she was not actively involved in this offense, maybe a complicity issue. So I don't believe that she is a danger to the community or a flight of risk.
I think the reason that the court gave her the bond is she was unsure of housing upon release. She had resided at the residence with Mr. Woodruff back on the trail for about 3 weeks, worked part-time at DoorDash, and had been unemployed for a year prior. Stated she had no help outside or no support, and so the court is concerned that her stability where she'd be upon release. With the $5,000 bond, she would be able to get out 10%, so it would only be $500 to take her out if the bond is perfect in this matter. We'll keep bond at $5,000. Anything further?
No, Your Honor.
Nothing further, adjourned. Mr. Armstrong, can you hear us okay?
Yes.
Mr. Armstrong, you can? Yes. Okay, your mouth isn't matching the sound. It's like delayed or something. So we are on the record on our State of Ohio versus Robert Woodruff, case number 21CR146. Case before the court, Mr. Woodruff was originally indicted on a burglary violation of section 2911.12, which is an F2, also indicted on theft violation of section 2913.02 and F5 on September the 14th, 2021. The court did issue bond in this matter in the amount of $7,500. This matter is set for bond review. Present is Mr. King on behalf of the prosecutor's office. Mr. Woodruff, you are present and can hear us, is that correct?
Yes.
And Mr. Woodruff is represented by counsel, Mr. Armstrong, in this hearing. Mr. King, is there anything on behalf of the state in regards to the bond in this case?
Yes, thank you, Your Honor. Given that the defendant is charged with a second-degree felony here and also appears to have a prior felony conviction for receiving stolen property, it's the state's position that the $7,500 bond is appropriate. Thank you.
Mr. Armstrong, anything in regards to bond?
As the court's aware, Your Honor, I was appointed, looks like the entry was signed on maybe the 15th and filed for record just yesterday. I have not had a chance to speak to Mr. Woodruff. I've only had some prior receiving, which I suppose would be an F4 or 5. And Robert, maybe you can answer if the court were to reduce your bond or lower to no R only. Do you have a place was I?
Yes. My prior felony, it was over 20 years ago. I just turned 19.
Okay, do you have a place to live?
Yes.
Where would that be?
7230 Wagon Wheel here in Hillsborough.
How long have you resided there?
The last 7-8 years, I own the property.
Okay. We'd ask the court to consider possibly lowering the or an OR only if in fact the receiving stolen property was that many years ago. I don't have the benefit of seeing his entire prior record at this point in time, Your Honor. Maybe Mr. King could speak to that. It appears that he does have ties to the county if he's lived there that long.
My report does show prior theft, 2 prior thefts, 1 in 13 and 1 in 17, as well as 1 in 01, and a breaking and entering in 01. Upon review, I do think the $7,500 bond is appropriate. I would remain bond at $7,500. I understand that if you're new to the case, you still have the right to file a motion for bond reduction for Judge Cost. At this time, I feel $7,500 is appropriate. Anything further?
No,